Your continued support of the CryptoQ Media channel is much appreciated. Greetings all. The Chief Executive Officer of Ripple argues that the court made a mistake in ruling that XRP is not a security. Judge Phyllis Hamilton sided with Garland House on the false representations accusations, but she rejected the class action applications that included other claims. However, Brad Garland House maintains that XRP is not a security. Regardless of the continuing legal battle, the latest order by Judge Phyllis Hamilton about the status of XRP has thrust Ripple CEO Brad Garland House back into the limelight, even though XRP is still making promising progress. As you can see from the post down below, Garland House maintains its position that XRP does not constitute a security or derivative. It has been picked up by many others. In addition, several of them have already brought up the fact that the news reports regarding the XRP class action lawsuits ruling yesterday by a judge in California have been false and deceiving. When Judge Hamilton gave the green light for the prosecution to move on with the charges of making false statements against Garland House, a major event happened in the courtroom. The fact that some of them are trying to make up is encouraging. The CEO, meantime, rejoiced at what he dubbed a big win: the dismissal of the class action lawsuits filed against him by the court. Among the most pressing issues is determining whether XRP constitutes a security. A prior decision by Judge Analyze Torres, who had stated that XRP is not a security, was the basis for Judge Hamilton's arguments against Ripple's president and the cryptocurrency. Judge Hamilton stressed in her most recent decision that a rational investor should not put all their eggs in the Bitcoin market basket and hope for a profit. Nevertheless, she did bring up Ripple's efforts to streamline the incorporation of XRP into other applications and services, including international payment systems. As Garland House noted, they had triumphed in a decisive battle. Despite the dismissal of all class action claims, the New York court's ruling on XRP sales nevertheless maintains that the cryptocurrency is not a security. Claims were made against Ripple that they may have broken federal securities laws. The prosecution had asserted that Garland House had sold millions of tokens on numerous cryptocurrency exchanges concurrently with its promotion of XRP, but the outcome of the case disproved all of those claims. As stated in the lawsuit, in response to the misleading assertions, how did he feel? Even more concerning is the fact that Ripple's CEO continues to hold the incorrect and concerning position that XRP is not a security, which I hope to explain during the trial. On the other hand, XRP's bullish momentum shows no signs of abating. Regardless of the ongoing legal drama, Brad Garland House, CEO of Ripple Labs, spoke up following the recent ruling in the XRP class action lawsuit in a California court. Throughout the piece, Garland House brought attention to the fact that some of the headlines regarding the verdict were deceptive. With the dismissal of all class action claims in the lawsuit, the New York court ruled that selling XRP did not constitute the sale of a security. Claims were made against Ripple that they may have broken federal securities laws. The outcome of the lawsuit, however, denied each of these claims. What exactly is wrong? Allegedly, Judge Phyllis Hamilton of the U.S. District Court for the Northern District of California rejected most of the class action allegations. Notwithstanding, the court retains the option to try a single claim based on state law. The plaintiffs in this case claim that Garland House, during a 2017 television appearance, made misleading claims about the sale of securities. Garland House vowed to be prepared to defend his beliefs at the trial. An analysis of the decision was provided by Stuart Alderdi, Chief Legal Officer of Ripple's. Alderdi expressed his satisfaction with the decision by the California court to reject any class action claims. This case will deal with the one surviving claim based on state law, which is an individual claim. In his last point, he brought up the fact that the plaintiff in question did not purchase XRP from Ripple, rendering them unable to confirm having heard the alleged misleading statement, and that they possessed a meager quantity of XRP when they were served with a lawsuit by Ripple CEO. Citing violations of California's securities laws, Clean accused Garland House of wrongdoing. In 2017, with the intention of being significantly long XRP and selling millions of XRP on many cryptocurrency exchanges at the same time. In the opinion of Ripple's legal team, XRP does not qualify as a security under the Howey test. According to Garland House, a security must meet a set of requirements known as the Howey test. He meant to criticize individuals who tried to make money off of the judicial system and to point out that the remaining argument was incorrect in his remark. He went on to say that this was a prime example of the trolls' failure to exploit the American justice system to their advantage, as they had tried in vain to get hundreds of millions of dollars in class action settlements by fabricating assertions. Both Elisa Torres and a U.S. District Court judge reached findings that are consistent with Judge Hamilton's decision. In a separate case, the Southern District of New York also determined that XRP is not a security. Brad Garland, CEO of Ripple, spoke out about the newest court decision that called XRP's credibility into serious doubt. As a non-security expert, he reaffirmed his position and detailed the fallout from the ongoing dispute. Following yesterday's ruling in the XRP class action case by the judge in California, there have been a plethora of false and misleading headlines. Many have brought this to light, and a few have gone so far as to say it out loud. The fact that some of them are making an effort to rectify the situation makes me glad. The decision by Judge Hamilton to move on with the accusations of misleading statements against Garland House is a major turn in the ongoing dispute. However, the judge's dismissal of the class action claims against Garland House is cause for great celebration. Judge Phyllis Hamilton of the United States District Court for the Northern District of California rendered this decision on June 20. With Judge Hamilton's rejection of further claims that Ripple had neglected to register XRP as a security, a case involving remarks made by Ripple CEO Brad Garland House can move on. These accusations were leveled against Ripple throughout the trial. Whether Garland House's comments constitute false information is the primary goal. That is due to Girardi. After the court rejected all class action claims, Riff Raff's top legal officer was pleased. According to what he said, the remaining legal intricacy would be resolved at trial, namely on the one state law claim that remained. Social movement activity and domination have both been on the rise, according to sentiment data, thus XRP might be in for some positive next developments. There is no further video after that. If you find my channel entertaining, please subscribe. Arriving soon, goodbye.